Everyone. Finally, the technology seems to be working. The original Spaces link I had would not open no matter what I did, so I just started this one instead. King, I see you're in as a co host. Can you hear me?
Loud and clear.
Fantastic. Ship, I see you're listening. I sent you a co host invite too. Hopefully, you can make that work. Yeah, there you are. Hey, Ship, how you doing?
Pretty good.
Pretty good. Did you get your filing done?
Nah, I've still got another 3 hours, so I'll get to it. I've got actually 4 hours, so I'll finish it when we're done here.
Yep, 4 hours. So it's almost done, you're saying.
Yeah.
Yeah. Okay. So this would be a good little break for you. Hi, Aaron. How are you? You wanna be included as a speaker? Since you've got a lot of experience with warrants and some of these geo fence warrants. Wave at me if you say yes, or give me the thumbs up, and I'll send you an invite. Um. Okay. So hi, Kyle. I see you. Do you want to join us as a potential speaker, Kyle? If you do, send me a request. I'll be happy to include you. Aaron, all right, I sent you a speaker. It won't let me add you as a co-host, but only as a speaker. Aaron, can you hear us? Got to unmute
I
yourself.
hear you. I hear you.
Okay, fantastic. I hear you too. Okay, all right. So I think enough folks are filtering in. Kyle, I'll send you an invitation to speak too, so I can add you. So you guys, this is great. We're going to have a bunch of lawyers and prior law enforcement folks. So that'll be fantastic. I've got, hey, Kyle, can you hear us?
I can. I hear you loud and clear.
Bank, hi. Good to have you tonight. And we've got my husband on. He's on here with me too, as folks probably know. He's a longtime lawyer, 50 years practicing law, Harvard Law, was a prosecutor for the feds for 10 years, and has litigated a ton of criminal cases. So got a bunch of experience on here. So what we're going to talk about is these geofence warrant cases, which have just come out. Though there are two circuits that have talked about this problem so far. The most recent opinion is from the Fifth Circuit, which is a more conservative circuit. And they issued their opinion. Let's see, what's the date on this baby? It's like, I think not, it's August 9th of this year. And then the Fourth Circuit, which used to be a very conservative circuit and now is somewhat not, issued its opinion on this. Let's see, they decided there's July 9th. So this is new law. So far, none of the other circuits have bubbled up. Anybody who's on here, do you guys know if there are any other cases on this issue bubbling up in other circuits? I don't happen to know the answer to that. Does anybody know?
Well, I'm going to guess the issue is pending
Yeah,
and working its way up, but the fact that the Fifth Circuit basically only refers to the Fourth Circuit in
yeah.
its analysis is an indication that none of the other circuits have yet weighed in.
Right, that's what I'm saying. None of them have decided, but does anybody know if there's any other cases actually pending in any other circuit? I don't know the answer to that. So eventually, some of the other circuits will weigh in, but already we've got a split on this. And it's an important issue, obviously. I think that this case will eventually make its way to the Supremes one way or another, but we're still a long way from that. Even on these two cases, these guys will have, 3 months to decide whether they want to ask the Supremes to weigh in. So, let me ask you, I have never dealt with one of these geofence warrants, obviously, since I retired before. Really, this issue's been being litigated. And I know Steve hasn't dealt with them either. King, you're retired. So let me ask the other three guys. Ship, these warrants were not being used when you were a prosecutor, right? They're too new for that.
Yeah, correct. They sort of sprung up about 4 years after I had left the department before they started to come into use, and then based upon the information that I learned just reading the opinions, the widespread use now is pretty stunning to me. I have no
Right.
idea they are being used in numerical numbers. And in fact, there's both cases, this is just an aside, both cases talk about how Google is modifying the way it stores or if it stores location data. And I think they're doing it because they are just getting so many of these and they're so expensive to process and take so much time. They're basically doing away with their data center so that they don't have to do it anymore.
Right. Google doesn't want to deal with that. I don't blame them. Okay, Aaron, I saw that I think had tweeted that you have had personal experience with this kind of warrant. Is
Yes,
that right?
I've actually used geofence warrants, and it's sort of its cousin. I say it's its cousin, cell tower warrants, which are very
Right.
similar in their effect. Um, yeah, have used them a few times, and they are extraordinary tools. Resulted in identifying, particular subjects. Same with the cell tower warrants were, very successful in what they did, and
Right.
um, yeah,
Oh yeah. It helps the government. There's no doubt about it. That's why they want to use them. So, but just to round out the conversation here, Kyle, do you have any personal experience with them?
So I never had to write any of them. I sat next to a guy who worked on CAST. He was one of the 3 or 4
Mm,
national headquarters bodies for CAST, and he was based out of Las Cruces. Really decent guy. But I got a really good look at what the toolbox looked like, and he would get tasked with stuff from all over the country as a national asset. So we would see what the returns look like, whether it be tower dumps, whether it be local law enforcement assist, which they did a bunch of. And then, of course, he was the guy that was actually taking a lot of the geofence information and transmitting it into like a usable, like, because it basically comes out in a spreadsheet. You got to be able to turn it into something on
yeah.
a map that does something for you. So he was the guy
Does
that would
something for you.
actually trace people in real time and try to figure out if a phone was in the area of a homicide or whatever else. So we did that for state and locals. I sat right next to him, so I looked over his shoulder all day long watching this stuff because it's fairly
Right.
fascinating. It's also terrifying because the toolbox,
Yes.
it's basically like looking into the past and having someone being able to kind of walk out there as long as you have a mobile phone on you, which is, of course, why all of the intelligence services require you to operate without a phone because it
Hmm.
transmits data everywhere and it goes into all kinds of different things that people don't even think about, even when it's turned off, which some of that we
Right.
probably can't talk about too much.
Right. I used to have folks from the Intel community that would, of course, I can't say who any of them are, and I would not, but they would come to meet with me in my office as a client. And they would either not bring their phone because they were coming to meet with me, or we would put their phone in a Faraday cage, which I had several of at the office because they just knew that that phone is transmitting data no matter what.
So
Right.
just
So,
to add to that, the Faraday boxes, the Faraday cages, the Faraday bags that people get, the commercially available ones, almost all of them leak. And most people don't
right.
really realize how much data is actually leaking in there. You can really do a test on this. It's worth doing for your personal security if you ever have clients in this situation.
Right.
Take the phone, put it in a bag, and then leave it on and send it a text message and you'll watch. It'll
And
eventually
see.
sneak through because it's just not, it's got leaks. They all do. It's just the way that they're
Right.
manufactured. So when I went, and this is actually a personal story, when I went to go meet with James O'Keefe, which I was probably
Hmm.
advised not to go do in DC, I left my phone
Right.
behind. I wrapped it in tin foil. I left it in a steel ammo box. Like I don't carry that thing
Yeah.
anywhere. And I carried cash and I rolled very, very low
Yeah.
visibility because if you don't want to be traced, you
Right.
can't have the device with you, which is what the government is
Right.
counting on. They can basically find whatever it pings, even when it's turned off, the battery is still pinging Wi-Fi
Right.
networks. It's pinging all kinds of different, leaving your ad ID in different places, and they get all this stuff.
Right. Well, the bag that I had, I didn't buy. I borrowed it from a friend, let's say. So I'm hopeful that that would have been a higher quality than what you're talking about. But yeah, I mean, I had clients who like they just knew, right? Because they're in that community, so they knew that's what it was. The rest of the world is walking around completely ignorant that this is even a problem, really. Especially judges who are technology phobes, usually,
well,
not always,
I
but
think most people think of it as like, well, I'm not doing anything wrong, so why should I be
yes, of
worried about it?
course. Why should I be worried? And this is a point that I often tell people as a former defense lawyer. Okay, but the law that applies to you who are not doing anything wrong and you don't have to worry about it, the law that develops is based on cases that are brought by people who are bad people, right? Who've done bad things basically. Some of them are innocent, obviously, but many of them are not. And so the judges are looking at these cases and making decisions in the context of someone who's committed sometimes a really bad crime. And that is the basis on which our rights are being determined often. So it's this idea that, well, I'm not doing anything wrong, I don't have to worry about it. That's not really protecting you at all, actually.
Can I
So,
can I jump in?
Sure,
Yeah,
King.
yeah. One of the opinions kind of gave you a list of the types of things that most people would consider very personal. And
Anybody hearing anything? I'm not
are you
hearing anything.
hearing me?
Yeah, I hear him. Kyle hears him too. Yeah.
Yeah.
Bill, why don't you log out and log back on again?
Okay. I think it's
Go
ship.
ahead, King.
Ship. We're talking about privacy rights.
Right.
I think the test is the standard test deals with expectation of privacy, and many things we do in life, we don't think about it, but inherently we consider to be personal and private and nobody else's business, particularly the government's. And
Right.
like somebody who visits an abortion clinic and stays an hour, a
Right.
couple
Or
of,
comes to see their shrink. Right.
go
Or
see a
comes to see their
psychiatrist,
lawyer. Right.
go see a lawyer.
Exactly.
Yeah, things like that are personal and private, and none of the government's damn business. And in this age of new technology, uh, big tech gets it all. So the
Right.
legal issue is, does the government get it too
Right.
automatically or with a warrant? That's
All
what we're
right. So
talking about.
let's set. That's what we're talking about. So
I-
let's
If
set
I
the
may add
stage.
something, the government is
Yeah.
now abusing this data too because they're
Oh, for
putting
sure.
people on lists like the terror data screening list and other
Right.
lists that impacts your rights to actually do stuff or to do so freely. You sort of see that with Tulsi Gabbard. She certainly didn't deserve to be
Right.
on that list, and
Right.
there are other examples.
Or if you happen to have a common name, right? This
Or if
creates
you
problems for you in your life if someone who's a bad guy's on that
or if you
list,
simply went to DC
right?
during
On certain dates.
right,
Mm-hmm.
you could be on that list and subject to additional screening because they got that data and they decided that that puts you on that list for enhanced screening, which would
Right.
suck.
Right. Which, and this whole issue just continues to impress me with the brilliance of the founders, right? The way they approached these kinds of issues over 200 years ago is still has resonance today. So we're gonna get to that. So just so people understand what we're talking about, let's lay a little bit of groundwork. So the Fourth Amendment to the Constitution says, I tweeted this out so people can see the text themselves. It says that warrants can't issue except particularly describing the person and place to be seized, etc. Also, as King was saying, that there has to be a reasonableness element to it. So the Fourth Amendment literally applies to searches and seizures. And so the courts have interpreted this to mean that warrants have to issue on probable cause for specific things. Searches and seizures can be conducted even without a warrant in some circumstances, but subject to a reasonableness standard and to the standard King was talking about it having an expectation of privacy. So that's the background law. One of the things that the courts have always said is prohibited is what's called a general warrant. Now, the Constitution doesn't use that phrase, but the phrase in the Fourth Amendment that says no warrant shall issue except upon probable cause and particularly describing the person, place, things to be seized, the courts have interpreted that to mean no general warrants. The founders were very familiar with general warrants. So in that time, the king's magistrate would issue a warrant that says, we think a crime's been committed by such and such a person. Go forth, law enforcement dudes, and grab all their stuff, basically. Go and find any evidence of this crime committed allegedly by this person. And that's the way a general warrant works. And that's just prohibited by the Constitution. But the problem is always in the details. The devil's always in the details. So, about, my goodness, maybe going on 30 years at this point, when technology for computers really was taking off, more and more people, individual, like normal, regular people had computers, and the courts started issuing warrants for computers. They were very broad. The technology was, of course, not as sophisticated as it is now, and the judges knew nothing about it. One of the main problems you see in this area of the law is that, as a general rule, lawyers and judges are not super technologically intelligent people. There are exceptions to that, of course, but the judge that I clerked for, the year that I clerked for that court, was the first year the court had computers, and that computer sat on her desk, not even plugged in, the entire year that I clerked for her because she didn't want to use it. And that was not that long ago. So we've come a long way since then, and there are some of the courts are very sophisticated in their technological analysis, but many of them still are not. And another feature of this area of the law is that the law is always behind. The technology is always racing ahead. And to Kyle's point and Aaron's experience too, law enforcement is using the tools long before the lawyers and the judges, especially the courts, get around to commenting on whether or not it's okay or not, because law enforcement is in the here and now of grappling with, issues of crime, issues of terrorism, issues of espionage, all of these things. They have to grapple with them, in real time. And then the courts come along later and say what's good and what's not good. But the courts are always, always, always behind the curve of what's going on in this for the man in the street.
Can
So,
I add one little piece to that
um,
too?
let me say one more thing, and then I'll let you jump in. So, the thing with these warrants, and I'm going to ask one of the guys to give us a little more explanation of how they actually work, is that these warrants the government uses when they do not have a suspect. So they don't know who they're looking for. They know that they're looking for evidence of a crime that's occurred. They're not just looking in general. There is a crime, but they don't know which suspect they're looking for. And so they're asking the tech companies, usually Google, and it does vary by company. They're asking them to give them data about users that were in a certain area during a certain period of time. And the courts have said that the Fourth Amendment covers people, not places. So this is one issue where you'll see there's kind of a disconnect between historically what the law has been talking about and what people our experience actually is in the modern world. Um, so the general idea here, though, is that the warrants are not asking for evidence to search a certain place. It's basically asking to sweep up, dragnet up all the records for a certain time and place. And to do that, Google has to apparently run its search through every single user's record in order to cherry pick out the people that conform to what's requested in the warrant. So they're literally searching everyone's records of it, according to the Fifth Circuit. Okay, so Kyle, go ahead and jump in. What did you want to say?
Well, it's also worth noting that because we have a blending of intelligence and law enforcement at the federal level in a way that you don't
Right.
see at the state level and you're not going to see at the local level. You have, for example, Washington field office for the FBI. They have an NSA skiff that requires special permissions, even if you have a TS and an SCI. You need a reason to be in it that is able to do tracking and real time and all kinds of wild stuff for which you sign additional non-disclosures. And that capability is housed within the same building where people are looking for Russian spies, looking for Chinese operatives, looking for, Israelis and take your pick, like Iranians and so on. But it also is the same one where they're like running after bank robbers and sending my old squad out to go look for people who were doing white collar fraud. And so when you have that same capabilities housed within the same entity, the crossover and the capabilities continue to be there. So as they push these envelopes and as tools are developed for exploits and so on, you're going to see that bleed over, which is necessarily, it's going to be in front of the curve, as you just said, but it's also going to move at a level that's faster than people are going to expect for even basic law enforcement. And so it's not just that they're developing these tools that your state police might have. They're literally looking back in time into something, as you said, pinging against everything, and they're finding all the people that were being there. And you can uncover things that would otherwise they would have had no reason to look for. So
At
and
all.
and
Right.
that gets really shady too, because they're identifying all kinds of information. It's not just Google, by the way. It's every app that you
Right.
have that's going to log Latin long, which many of them do, because they want to know where you are to be able to sell to you. So they're gathered theoretically for this sort of marketing purpose. That's the reason what they want to do it. And they just gather up data. And then at the same time, it can easily be used for law enforcement to pinpoint where you are, what your patterns are, who you're around, which cell phones hang out with which cell phones. And it's really, really convenient. But it's also incredibly dangerous to personal liberty. So there's got to be a
Right.
balance there.
Right. Okay. So you said lat long, and I bet a bunch of people don't know what that is. So tell us what that means.
Sure. So everybody's going to be generating wherever you are with your cell phone. You're generating a probably a 10-digit grid coordinate that says exactly what square of the map on the world you are in, and so your latitude and your longitude are being pulled off the GPS chip that's on your phone. And whenever you're giving access to location, which many different apps request, and most people default to saying yes because they're not necessarily sure what they're saying yes to, you're giving your Facebook app, which I don't have on. You're giving Twitter. You're giving Google searches. You're giving whatever you have an account, Apple, and so on. All of these different tech companies are gathering where you're at as often as they can reasonably do so without destroying your battery. And so you're giving real time updates, just like you're doing with Find My Friends. And maybe if you have an iPhone, you know what I'm
Mhm.
talking about. You're telling your buddies and you're telling your wife, like, you can look and see that I'm at the grocery store. You don't have to ask me where I'm at. But they're pinging that off a big tech company that's grabbing that for everybody, literally everybody who has a smart device. And the only way to really hide that kind of stuff is if you have anonymized technology. So my buddies and I would go into the store and we would buy 4 different Samsung phones, and they would ask us, who do you want to register this under? And I would say, I'd register it under AT&T customer, please. And they'd say, what's your name? And I'd say, my name is AT&T customer. And so they would give you a
Yeah.
weird look and they'd sell you the phone. And then another guy would go do it. And they're all three like FBI agents who are in good shape and relatively good looking guys. And then they would think that we were all having like some homosexual tryst in the office, which is really funny because the only people who do that are drug dealers and sort of
Drug dealers.
spies. That's
Yeah.
the people who
Right.
do burner
Yeah.
phones like that. So
Right. Yep. Exactly. So if you watched House of Cards, you saw the little old ladies using the burner phones, right? Well, she's a Supreme Court justice or something, supposedly, but yeah, and she had learned about that from the drug cases. So that was pretty funny. Right. But this is the thing, is that we live in a world now where you you are walking around thinking you're living your life in private, but you're not, because the government can get your stuff, your information, even stuff you don't even know that you're throwing off. So, and it's the law, as I said, is catching up sort of slowly, but also there's always this tension with these cases that there's the need for law enforcement to be able to ferret out crime. And so any tool that they want to use that helps them does help them, but the question is at what cost for the rest of us? And there's just this long history in the law of the courts expanding the law enforcement's use and their ability to use things and cutting back on what was originally conceived of as protections for the average person. So I remember when I was in law school and we learned this area of the law, you read the Fourth Amendment and the founders are all against general warrants and, down with the king, coming to search your house, and it's all sounds great. So we passed the Fourth Amendment and we all have these rights and protections. And then, along about the late 1880s, the courts really radically change their view on it. So, there's a case in the late 1880s called Boyd, where the Supreme Court is basically saying the Fourth and the Fifth Amendments protect your private papers from being used against you in a criminal case. The idea there being that it was, just inappropriate for the government to come into your house, take away your personal papers, your diary, your notes, your of course it was all physical then, paper actually, and you to use that against you in a criminal case. The Supreme Court just said, well, that's just not the way we do things. That's anathema. And it's funny because in modern times, when I tell people, well, the government doesn't even need a warrant to get your old emails, right? Or they don't even need a warrant to get the phone company to do what's called a pen register, which shows which phone numbers have been dialed. It doesn't show the content of the call, but it shows the numbers going in and out. And people are horrified by that because the average person walking around thinks, of course, that's private, but the law does not say so. So after this understanding of the first century of Fourth Amendment jurisprudence, it really, really has radically changed in the last century. And now I feel like we're swinging back the other way. So in the 1900s and the 20th century and the early part of this century, like the 2000s, the law was mostly favorable to the government on all these Fourth Amendment cases. But then what has happened is that the cell phone revolution is now upending the law again. So, Ship, can you talk to us a little bit about that, in terms of kind of where is the Supreme Court now on smartphone technology and warrants for computers and that kind of thing? Can you hear me, Ship?
Yeah, I can.
Yeah, go ahead.
Repeat that question again. I had a call come in that I had to decline, and I missed the middle of your question.
Sorry. So I want to give people a flavor of sort of pre the most recent cases. So let's say from 2010 until now, the last decade or 15 years, what the law looked like in terms of what the courts would allow for searches of computers and phones and that kind of thing.
Well, the courts got more restrictive in limiting the scope of the data that could be looked for. Any search warrant has two attachments with it. It has an attachment A and an attachment B. Attachment A is the item to be searched. Sometimes it's an address to a house. Sometimes it's the serial number to a cell phone. It's what the government wants to search, and then attachment B is the types of information or the types of evidence that the government is searching for. That has to be uh, particularized, if that's a word. It has to set out with particularity the items of evidence and their connection to the crime that's under investigation. So, what developed over, I would go back even a little further, I'd say between 2000 or maybe, well, if you went all the way back to computers, what developed was more exacting standards for attachment B.
Right.
Not just open-ended general descriptions of material. And an analogy that was used, if you went back 25 years, an analogy that was used in the early days of computers was, you called it the file cabinet rule. In other words, when before computers, if you had a search warrant for somebody's office and you had a search warrant to seize files, you had to describe what documents in the files were relevant to the investigation. And so when the agents went in, generally they had to look through the files for documents that were relevant to the investigation, and those had to be described in attachment B. It,
They couldn't just take the file cabinet.
exactly. That was what was prohibited, which was just take the whole file cabinet, put it in the back of a truck, haul it down to FBI headquarters, and then just photocopy everything. That was considered a general search. They just went in and took everything. So it obligated the agents to search through the records, looking for. They could look through all the records, but they could only seize. They could only take with them the records that fell within the the categories of the warrant approved by the judge. So then the question becomes, okay, so what do you do with a computer? It's just a little box, and it has everything stored in it digitally.
And
And
you can't sit there in the guy's office for 12 days going
exactly,
through all of his files. Yeah.
exactly. So tools were developed and protocols were developed where the authorization was to image. They could take the computer, or in certain instances, they would have a tech agent simply mirror the drive. So you create a mirror image of the drive that's on the computer, and then take that. But then the a specialized agent, Kyle can describe this a little better, or Aaron can describe it a little better than I can. A specialized agent uses a series of tools to download the database, or download into a database all the contents of the hard drive on the computer, and then segregate them or isolate them in ways that allow the agent to use search terms to pull out specific files that fit the criteria of what is being searched for, and not pull out of the computer items that are unrelated to the crime that's under investigation. So you preserve the privacy of the owner of the computer in the materials that have nothing to do with the case. They all get isolated into a database that nobody is supposed to look at, and then the agents are authorized to examine the files that search terms have been used to determine have information that might be relevant to the investigation. Um, so that was sort of the general approach, and then
For
obviously,
a long time,
yeah,
most of the years that I was practicing, this is how this worked. And then the
and
smartphone
then the
revolution.
smartphone changed
Yeah.
everything. And that's, I think, I
Yeah.
kind of trace it back to about. I remember I've got an iPhone 4 in 2011, and I think the iPhone 4 was Apple's first internet capable phone. Allowed you to sign on to the internet, and from there all things became possible. That was
And then
really
as you say, the courts got more and more uncomfortable with letting the government just take people's computers wholesale. Or over time, the judges got more informed about technology. And as a defense lawyer, you could make more headway saying, well, they can't just take everything. Come on. Right. It has to be more particular than
right.
this.
And what the fight, the battle in courts began to take shape over when the scope of the search of documents contained in the electronic device or materials in the electronic device, the scope was too broad. The scope was too general. And so
Right.
you were still litigating attachment B. Was attachment B specific enough or particular enough to limit the search to materials relevant to the investigation and to exclude from the search materials unrelated to the investigation? Law enforcement always wants to push the boundaries so that they can get their hands on as much data as possible. And defense lawyers are always arguing to restrict those, to interpret
So,
attachment B
yeah.
very narrowly, and then argue that what was actually done by the tech agent and by the investigating agents was overbroad. And
Right.
because an overbroad search, this is an important point, an overbroad search creates the possibility for having the entire thing thrown out, not just the overbroad part. A lot of people don't understand that. You know, if you challenge a search as being overbroad and are successful, the remedy you're going to ask for is for the entirety of the search to be suppressed, not just the overbroad part. And
Which
that's,
is a point that gets raised in one of the cases we're going to talk about. So we need to remember that point.
yes.
We'll come back to it.
And,
Yeah.
and, and the purpose of this, and this is something that a lot of people don't understand, and so I'll just mention it briefly, is the Fourth Amendment has no remedy. There's no remedial provision of the Fourth Amendment about what should happen.
It just says you're not allowed to do this.
Right,
But then what happens if you do?
right. What has happened is over I can't remember what we all learned about in law school, con law or evidence, but Supreme Court in a decision, and I can't remember which decision it was, basically crafted what we all referred to as the exclusionary rule, where the court excludes the use of evidence that is illegally or unlawfully seized, evidence that is seized in violation of Fourth Amendment, either because it was obtained without a warrant when a warrant was necessary, or it was in some other fashion obtained in a manner that is deemed by the court to be unreasonable. And so, but the exclusionary rule is really just a court fashioned rule to punish the government for purpose of deterrence by saying your misconduct here costs you the use of the evidence that you probably think you need. So it's a tool employed by the courts that basically says the court will not be a party to the executive's illegal conduct, in the sense
Right.
that
This is supposed to prevent them from doing things that otherwise the public kind of wouldn't be able to prevent the government from doing to them.
exactly the only other remedy, and some people have mentioned it over the years, is, well, rather than letting guilty people go free, somebody who is unlawfully searched should just be able to sue. and win damages against the government, but we should not suppress evidence of crimes that is seized from criminals.
Bad people did. Yeah, the problem with that theory, of course, as a practical reality, is suing the government is a fool's errand most of the time.
Right,
So,
right. So that's how the Fourth Amendment gets enforced. It is in effect a declaration by the court that it will not be a party to the illegal conduct or the unconstitutional conduct of the executive.
all right. So to continue with our history, so then the cell phones came in, and for a while, as I remember it, we were litigating sort of computer seizures were one kind of motion, and then the cell phones were a different, still a motion under the Fourth Amendment, and to suppress because the data that was being generated was different. Um, but this is just in the period before smartphones came along. So people had cell phones and there was data associated with that, but not the kind of data that we see now where everyone takes their phone everywhere and their phone does everything.
Well, a big difference was you think in the early days, you know, even primarily pre-internet of using computers, everything was on the computer, and maybe you had a
Right.
server in your office that gathered information from the collection of computers in your office. But then after that, the internet comes along, and then you have third party providers. Well, cell phones always had a third party involved. Cell phones always had the cell phone company to start with
Right.
that you obtained the service from. And then, once cell phones became internet capable, you had the internet service provider, which sometimes was the cell phone provider and sometimes was not, depending on how you set it up.
Right. And the reason the motions were different was because the law was different, right? So there's law respecting telephones that goes back way, way back to the almost the invention of the telephone. So there's old cases talking about what lawyers call pen registers, which is this idea that the phone company in the old days had a way of keeping track of what number did you call from your home phone, what number was being called into a business. And the courts came up with what I have always thought was a farcical fiction that said, well, you didn't have, as King was telling us before, an expectation of privacy in who you were calling or who called into your company because the phone company had those records. This third party outside of you, third party, the phone company, had those records. And since you voluntarily shared that information with the phone company, not that you had a choice, right? But since this third party had this information, therefore you did not have a reasonable expectation of privacy, and therefore, it when the government demanded those records from the phone company, that was not a search. And I always thought that's a load of crap because people don't go around thinking, oh, well, I'm dialing these phone numbers from my home phone and AT&T, Ma Bell knows who that is, but that doesn't mean the government gets to know, right? But the reason that the court said that you didn't have a reasonable expectation of privacy in that data, I always thought, was because if they said you had a reasonable expectation of privacy in it, then the law enforcement wouldn't be able to get it to use it, and they wanted law enforcement to have it. It just seemed to be straight up as simple as that.
Let me throw a phrase out there, and Aaron might remember it. I'm pretty sure Kyle won't remember it. Who remembers the phrase spindle, pair, and binding post?
I do not remember that. Maybe if you
King
refresh my
King
memory.
might.
That was the technical description of how a pen register
Works. Yeah.
was actually physically attached to the switching or the switch
Mm-hmm.
before telephones went digital.
Right.
Yeah, so
Analog phones.
that's a little. Mine is mostly digital. I mean, I remember getting, we'd subpoena statements, telephone statements, and we had software, and we would have to basically enter it by hand into this software that would then do the analysis of the pen registers of, who was calling who, uh, and that was pretty. When we finally got that automated, that was a pretty big deal.
Yeah, well, the spindle parent binding post, it goes back to the era of
Or that even, yeah.
the rotary dialing phones rather than
Right.
the push button electronic phones. So Steve probably remembers that.
He probably remembers the warrants for that, but yep. So, yeah. So there was this old body of law that talked about how the government could get that because obviously you'd shared it with the phone company. When I read those cases at first in law school, I was like, are these people crazy? Have we all gone insane? Of course, the phone company has that information. What the hell does that have to do with whether cops should be able to get it? But that was the rule, that somehow that was, you didn't have any expectation in who you were calling on your phone because the phone company knew who it was. And as I look at that now as a retired lawyer, King, what do you think of this? To me, that seems like it's against most of the way the law works. The phone company was your agent, right? You're paying them for the service. How could they be a third party with whom you didn't have an expectation of privacy? It's not like you voluntarily gave your information to someone who didn't work for you. That I would make sense. If you give your information to someone else, then obviously you don't have a reasonable expectation of privacy because you yourself shared it. But that rule doesn't normally apply when you're talking about people who work for you. Go ahead, King.
I agree 100%. It's more than just work for you. Um, Let me give you a hypothetical. Let's say I stabbed my neighbor. We'd had a fight, and I pulled out my knife and stabbed him and got blood all over my suit coat. If I took my suit coat to the dry cleaners and said, please get this blood stain off of there, I don't want the cops to see it. That's just a relationship that is inherently non private. There's no expectation that my dry cleaner isn't going to tell everybody in the store, call up the cops.
Right.
If I'm dumb enough to do that, shame on me. But there is no privacy expectation in that transaction. On the other hand, a phone is a mechanical device, mechanical slash electrical device that does not work except through the infrastructure built up by the phone company
That you're paying.
that you pay for a service. And there is a privacy expectation about some of the things that go over those lines.
Right.
I can talk to my lawyer. I can talk to my priest. I can talk to my doctor. Uh,
Your wife.
my
Right. Yeah.
wife, although that's never private, but it you get my point.
Yeah.
It's an entirely different situation, and the courts went off in a wrong direction, I think. Uh, but that's the law.
Right. And at the time, this is back in the first part of the 20th century, they were trying to catch bank robbers and, mob guys and all of this stuff. And so they wanted to be able to use that technology to law enforcement's advantage. And so the courts came up with this stupid rationale. And nobody said you can't do that. Now, the Congress, in response to some of these cases, did create like the wiretapping statutes, right? They didn't want the courts to go so far as to say, well, the phone companies, if they have the content of your phone communications, they can turn that over too, right? So sometimes the Congress has weighed in and cut back on what the courts either did or where they were going, because people do think there should be, phone company or no phone company, they do think there should be an expectation of privacy in your actual conversation with the person that you're talking to on the phone. So there is a certain balance there, and it is supposedly is based, the courts say it is based on this, what a reasonable person would reasonably expect to have remain private. But I have always thought to myself that actually the judge's rulings don't reflect what normal average people think is private or think should be private. It's the courts, I think, err on the side of allowing law enforcement to have access in situations where if you took a vote of the populace, that it would probably would go the other way. All
E-
right,
e-
so
e-
now, go
Except,
ahead.
we're talking tonight about a court that has gone in the other direction.
Yeah, exactly. Has gone in the way that I think the people would go.
At which point,
Okay.
by way of full disclosure, the opinion of the Fifth Circuit that we're discussing was written by Judge Carolyn King,
Mm-hmm.
formerly known as going, formerly went by the name Carolyn Randall. She was appointed in the late 70s by Jimmy Carter. She's 86 years old.
Good for her.
And I've had a crush on her for 45 years.
Oh my God, King.
And there's a King story that goes with that about why I have a crush on
All
her.
right, so save that.
Okay.
We'll get to that at the end. Kyle, you have a comment?
Comment and or question, I guess, towards the
Yeah.
panel. I've seen it on the national security side, but what I haven't seen are warrants that return information regarding the sort of spyware devices that people continue to buy. So things in your Apple
Mm,
account like Siri or your Alexa, many of which are sampling the air at all times and theoretically delete it, but probably don't based on what we know about these tech companies. And so I've seen it on a national security side that they can actually be gathered and they can be exploited. I don't know if there's a warrant that is being written for those. But I'm curious if maybe Aaron's seen it or if Ship's seen it in any of the current work he's doing.
yeah, and the J6 cases, you see anything like that, Ship, where they're getting data from? I mean, the government's been mining mostly Facebook, right, for the all the stuff they're using against those folks. But are they using Alexa and Siri's too?
I haven't seen that. You know that
Yeah.
I will, and I will suggest the reason I haven't seen it, and I don't think they're doing it, at least as to January 6th. They don't need it.
They don't need
I,
it. It's all on Facebook.
oh, it's on Facebook. It's in text messaging. It's in
Yeah.
their, it's in their iCloud accounts.
Yeah,
Yeah.
It's in so many places that's easy for them to access under the law as it exists now.
Yeah.
Once they have a individual identified. Yeah,
I'm trying
and so
to remember what I got because we would run warrants on Apple and Google accounts like I mean probably a dozen a month in my task force. Like we would do so many, it was just crazy. Um,
Right. Is this is what people don't understand either. It's totally routine. All this for the government at this point.
yeah,
Completely routine.
although geofencing was a lot more is very time intensive, but like Google account, like once we identified a person, like we would go after their Google accounts and we would literally run warrants like a dozen a month. We probably had one
Yeah.
one each easy um, in these cases, but so I was trying to think. Google comes back. The problem is a lot of it stuff translates. Like if you say, "Hey, Siri, dial this number." I'm not sure that they're keeping like that information. What your phone would give back would be the
Mm-hmm.
dialing of the
Yep.
number. It would be like GPS data. It would be like Google would return everything that you searched. Like so, search terms that
Yeah.
you saved. It would have that. It would have GPS
That's
data.
how all these killers get caught, right? Because they've searched how to kill your spouse without getting caught and shit like that, or how to poison someone with home remedies and whatever. And then, then 3 months later, when their spouse turns up dead, those searches still exist.
And
And
there's
it's
been
so easy. All they got to do is go to the library where there's an
Right.
anonymous public computer and do these things. But people are dumb. Look, people are
Right.
lazy, and that's the
Yes.
worthwhile thing to talk about though, because people are trading convenience for privacy, and you're all doing it, and I'm doing it too. And as long as you know
Right.
that that's the transaction you're doing, it's not nearly as big of a deal as if you don't understand that every time you say something, you're giving a voice sample and a search term and potentially a recording of yourself to whether it be Amazon or Google or your iCloud account. All these things get stored because storage is really cheap, and that didn't used to be the case. That is an advent that I don't
Yeah.
think the courts have really caught up with. How cheap and
Right.
easy it is to keep all of this stuff basically forever because they just keep expanding their storage capabilities.
Right.
well,
All
and
right. So
that
let's
that
continue with our
that
progression. Go ahead, Chip.
that brings up an interesting point about this Texas case where they point out that Google stores data for 600 million users
Right.
in one database called Sensor Vault. The location server, the location data for 600 million phones is in one database. And
That's great.
that was as of like 3 years ago. So who knows what it is now?
Yeah, and it does change, and it is company by company. So let's continue with our progression. So as we move into the 2010s, the cases start to change. They start to turn a bit more in the favor of the defense. But it's slow because the courts are behind, and the Supreme Court doesn't speak very often to this issue. But in 2012, the court said in a case called Jones that the government can't, that it's an illegal search and seizure of you if they stick a tracker on your car and just follow you everywhere that you go. And the government actually argued that no, that's not, because they could, in theory, stick a cop on your tail to tell you everywhere you go, which is, I thought, are you fucking kidding me? They would never do that. So how are you saying that that's something that you would do? Because you wouldn't. But the court said, no, that is a search and seizure unconstitutional because it pulls in more data than they need, was part of the rationale. And so this case, Jones, is sort of the first cracking open of the door that you see where the court is kind of importing not just a reasonable expectation kind of analysis, but also this idea that there are anonymity kind of ideas that go along with this, that you should be able to conduct yourself out in the world at large without being surveilled 24/7. Now, the court is still saying that those are privacy issues, so they're trying to slide this idea under the heading of a reasonable expectation of privacy. But in other contexts, the courts have said if you're out in the world walking around, that's not private, that's really anonymity. And what's interesting is that the Europeans draw a distinction, a strong distinction between the two. And actually, in Europe, under their rights, what comparable to our Bill of Rights, they have a right of anonymity that we sort of don't have incorporated fully in our law. So, but the Supreme said, okay, no, government can't track people that way. But they still kind of tied it to the fact that it was a trespass onto this old idea of a physical intrusion into your personal property by sticking the tracker on your car. But since then, now, and of course, everyone and their brother, including, children, now have smartphones that go with them everywhere and track everything they do, as we've been discussing. So now we're seeing more and more of these cases about, well, how much of your life can the government, basically peruse at its pleasure? One thing I see as a favorable, as a positive, is that the judges started using smartphones themselves, right? Like in their regular life, they started being able to understand the applications. So that Carpenter case is 2018, isn't it, Ship?
Yes.
Yeah. So Jones is 2012, and then in 2018, Carpenter comes along, another Supreme Court case. And there they had to figure out, this was the cell phone location case, right? I got that right? Um, and the courts set out a rationale for why using data from cell phone location is a search for which a warrant is needed. Because remember, if it's not a search, then none of these rules apply. So the government often argues as a first line of defense when they're trying to get the data in that, well, it's not a search. So in this Carpenter case, the cell phone location case, the Supreme Court said, well, okay, but all this data that you're scooping in that Kyle was talking about from the cell phone company gives the government the ability to basically see everywhere that you went. And they get that just because the person turned on their phone. So the court viewed it as very all-encompassing, extremely intrusive, right? Because your phone going around pinging off the cell phone towers would let the government effectively track you, just like the phone tracking on physically on your car. So they kind of extended the law to this idea that your phone is effectively the same as the tracker that they said was prohibited before. So now basically the courts use this Carpenter case as the standard against which to judge current cases, because Carpenter is 2018. And I really think the pandemic has an unexpressed influence on what we're seeing now, because I really think that has had such a profound effect on everyone in our culture. that it is influencing people's ideas about what is private and what isn't private, and the smartphone revolution. Okay, so now these two cases have come forward this year. Both courts are analyzing basically the same problem, and they both purport to be applying Carpenter. But one court came out one way and one the other. So the Fourth Circuit said these warrants that are called geofence warrants that are constitutional, and the Fifth Circuit said no, they're not. Now, big picture, the Fourth Circuit said it's not a search, and the Fifth Circuit said yes, it is a search, and the third party exception doesn't apply. We don't care that Google has the data. Nevertheless, it is still a search, and it's a general warrant. So back to our old idea of they can't just say, we think this person did something wrong, go find the information. They said, nope, this is a general warrant, doesn't particularly describe. That's unconstitutional. Now, technically, the Fifth Circuit affirmed the guy's conviction because they said that even though it was a general warrant, that the cops acted in good faith because they couldn't have known it was a general warrant because no court had ever said that these warrants were a general warrant. So in that guy's particular case, they did not reverse his conviction, but that case, stands for the proposition going forward that these warrants are general warrants. Eventually, the Supreme Court's going to have to decide which is the right theory. But so let's talk in particular about the two cases now. So who wants to kind of really explain how do these geofence warrants work? What is the government trying to do? What are they getting? Why are they doing that? Kyle and Aaron, you want to speak to that?
Well, it's a spreadsheet. So for folks to understand it, basically it's going to give you a complete timestamp of a fixed location. There are some artificial boundaries applied on a map, and all of the returned data from whatever
Oh,
company
do
that
we
you're
lose them?
dealing with
Oh,
is Aaron can't hear me. We'll have to do a tag out in a second. All of the data dots that basically are showing up at a specific time are going to appear within that fixed sort of geo fence, the fence that is artificially applied and masked over the top of this map. So you'll have all these unique IDs, and then you can go back, and once you have that, then you can write additional paper and find out who that person was and what they were doing, and then maybe track that through space. But if you want to get a list of potential targets, you simply drop down this quantum. Imagine if there's like a bunch of bugs running around in the world and they're all ants, and you take a big glass dome and you drop it over a specific area. All the things that are inside there at that exact moment are what you're going to be able to get, and their location and relative distance to each other. And sometimes you can get heading and speed and all kinds of other wild stuff too. So depending on how specific the area is, you may get very little, you may get non-specific locations, or you may get like really, really detailed points depending on the number of hits that the phone has with multiple towers and or multiple devices on like a Wi-Fi network and so on. So it's also not perfect science is the other thing, because if you're doing something
Right.
like they did in January 6th, where they said, well, if you were across this line, then you are now trespassing. But if you were on the other side of this line, then you were on the fair game, lawn. There's a degree of uncertainty that always comes with trying to map things, just like anybody who's ever used their GPS, and it's going to be relative to what the phone's able to put out and relative to what the network can handle and so on. So it's not it's very good as far as being able to like hone in on the people that are around there. But as far as saying like this person was 5 feet from the tree and this person was 4 feet from the
Right.
tree, they
Right.
always are
It
doing that kind
doesn't
of stuff
work.
too, and
Yeah.
trying to
All right.
negotiate how good
Exactly.
they can get. The other thing is we've done it in arson cases out on reservations where there's really, really poor coverage. And what you'll find out is that like you get like basically everybody on the res because it's just anything that
Right.
touched
Drove through
any cell
there.
phone,
Right.
totally useless to
Right.
you. So you're like, okay, well that didn't help us. So
but
Right.
the
So
types of
like the
cases
House
we
Blue.
usually use it on are, I think murders and kidnappings are probably the number one. Kyle mentioned
Right.
CAST. My partner at the FBI was one of the CAST team members. Worked a lot of high profile murders. But we did use it a lot for cyber crimes where we knew a crime was taking place at a particular place, and whether they were using burner phones or whatever, we couldn't identify a particular person.
Person.
So a
Right.
crime happened at a particular place. You're trying to identify that particular person. So you're trying to be, you're not trying to scoop up more people. You're actually trying to narrow it down to fewer people, right? So, and there's a lot
Right.
of different ways to do
Right.
that.
Right. The law enforcement objective is good in a sense, right? We know a crime took place. We're not doing this when there's no crime. The crime definitely took place, or there's suspicion that it's happening, and we're trying to figure out, okay, well, who done it? Okay, well, law enforcement does whodunits all the time, and there's all kinds of tools that historically even you can use for that. Um, were used for whodunits. But the problem is that in order to narrow it down, as Aaron is saying, is they have to look through literally everyone's record to figure out whether you were in this box that they've drawn on the map that they're actually interested in. So the courts trying to analyze this, they both say, interestingly, King, Ship, did you notice this? Both courts say, well, we think this is a pretty straightforward application of Carpenter, and then they both come to different conclusions.
Well, yeah, they each looked at a different issue.
Yeah.
And I just
Well, they each analyzed the same issue a different way.
right. I want to build on what Kyle and Aaron have just said, though, because it's kind of spelled out. The process used by Google was actually developed by Google. Google basically said, look, if Google's in-house attorneys said, we need a procedure to follow to respond to these warrants. And Google developed, working with law enforcement, a 3-step process. The final step ends with, identifying the user of the identified device in question. But as Google explains it, the first process is simply determining it's just this broad. And this is where the Texas court or the Fifth Circuit stumbled, or where they had a problem. The first step is simply what users of the 600 million had location services turned on at the time set forth in the warrant.
Inside that
Yeah.
box on the map.
So they
Right.
have to do a search of all of SensorVault, the database with 600 million users, just to find out who had location services turned on. Then that became subset 1. And then they would give that information to, and it was search 2, or step 2 was, of those people that had it turned on, who passed through the physical location at the appropriate time. So now you've got a much smaller database of you have a subset of 600 million had it turned on, and a subset of the people that had it turned on were in the right place at the right time. And then that information, still anonymous, all we have are identifiers for the phones, not the names of the users. That then goes back to law enforcement. And then, in the ways that Aaron and Kyle were describing, through a process, mostly through a process of elimination, that second subset is whittled down to potential perpetrators, so to speak. So some of the examples
Right.
that
So
they
still
give,
not suspects, just
right?
potential
Yeah,
suspects.
yeah.
Right.
So some of the ways they whittled it down from that second group into the third group is a device that just appears to just be passing through the scene. In other words, it never stops. It moves into the box and out of the box without ever, like it's in a car driving down the street going past the
Right.
location. Okay.
Right. You're talking to me on the phone while you're commuting, and so you drive down that street.
Right. So using a variety of elimination techniques, they whittle that process down even further. I think in the Texas case, that involved was that a post office theft? I can't remember.
It was a postal employee assault, I think.
Yeah,
Yeah.
postal employee assault, and I think and the theft of mail, that the expectation there would be money or something in the mail, and I think that was reduced down to 19 potential targets. The Fourth Circuit case, I think it reduced it down to 3. That was a $195,000 bank robbery, I think, and the number of possible individuals was reduced down to 3 in the Fourth Circuit case. So,
and just
So
so
you
you know,
can
I
see
would
the
be
logic.
thrilled with 19, and even like 3 is like a goal, like you struck the lottery.
yeah,
19, I
Right,
would have
with
been
3.
thrilled.
Right.
yeah,
Normally, you're
19 is
talking
still a
like
lot.
hundreds. Like you have
Right.
hundreds, and you're trying to figure out, which ones to narrow it down to. But 19 is at least feasible to look at. 3 is incredible.
yeah.
Now, the problem from a civil libertarian's point of view is that now you're investigating 19 people, uh, almost all of whom are innocent. You already know that they are. Right, but you're still investigating them as potential suspects in a crime. um, and that seems kind of problematic to me.
Yeah. So the
But
way the Fifth Circuit approached it, the Fifth Circuit looked at all three of those steps as being three different searches. And
right, and you can see the logic of it, right? Like you can understand, right, why the tech companies are doing this way. It's strictly a logic tree. What's interesting about that is that's not the way the law looks at it at all, right? You can't just the government, if it had this database, couldn't just say, oh well, we're just going to ping everyone's record to see if you might happen to have been in this location that we're looking for. The courts would definitely say that was a general warrant.
well,
Mhm.
that's what the Fifth Circuit said about the very first step. Just who
Right,
had it turned on, who had location services turned on. The court said that's just a general search.
right.
That's not a search guided by any probable cause at all. It's just the
Vis-a-vis the person, right.
right. The warrant tasks the company to search Sensor Vault for who had services turned on. And it stopped right there. It said that's a general search, that's a violation of the Fourth Amendment, and everything that comes after that is invalid.
Right. What's interesting is that the government's arguing, well, the Fourth Amendment applies to people, not to places. But here, because you're still searching, because of the way it works, they still have to search individual users' records, right? So you're still actually investigating those individuals, is what you're actually doing, under the guise of we're only looking for people who went through a certain location.
Yeah, so
The opinion goes into great detail about what happens at the Google end because they don't stop at searching 600 million users. Uh, they once they identify a subset, then they have an algorithm that associates some relationship between this phone and a possible perpetrator. They apply different techniques to narrow the field down to something that's useful to the investigators, and all of that involves searching into data that is private and personal to the owner of the phones.
So why did the Fourth Circuit go the other way? King, you want to tell us about the other case?
Uh, they they just went with
This isn't a
it,
search.
yeah
That's what they did.
they just said they took a very high level approach. They did not
Yeah.
get into the detail that the Fifth Circuit did uh, as to what Google had to do to narrow the field down. They just said uh, no expectation of privacy, and uh,
Because Google's a
so
third party company,
it's a
right?
third party. It's not, you don't need a warrant even.
Well,
Right.
there were some interesting facts that they pointed out that were not carried over or ignored by the Fifth Circuit, and that is that they claimed that 2/3 of users opt out of location services, and
No, it's the other way. That the default is you're not in it and you have to turn it
Yeah,
on.
that was the big
So
difference
that,
between the
okay,
two.
all
What
right, all right.
yeah.
So
the
the
fourth? Yeah,
two thirds of users were not in or did not have location services activated, and so
By turning it on, they said that was part of the voluntary transmission of the data to Google. Right. Kyle, I
distinguishing
agree with you. That's a bunch of happy horse shit.
yeah,
But that is what they said.
distinguishing it from Carpenter, which said basically
Yeah.
just by powering up the phone, you're giving the location data involuntarily. Where here they went through in the chat read case, I think it was cat read case in the Fourth Circuit, they went through all the steps. I mean, they mentioned the several steps that a user has to go through to make to deliver their location data to Google, and
Right.
treated it as a voluntary participation in location services that eliminated your expectation of privacy in that data, and therefore accessing the data was not a search. And they also made it.
Hilarious,
But
hilariously, the Fifth Circuit judges said, well, opt-in procedures are not really all that informed with users.
Well, and the
There,
other
there,
thing that the other
there's
thing
not.
that
There's no way you can argue that people are reading the terms of service and as they accept these
Right,
things, that they actually
right.
understand and that they should be binding. The other thing that people don't realize is exactly how unique this data is, because it's not just that it's your phone that has some ad ID number or some Google account number that's associated with it. It's the updates that you have. It's the unique number of apps that you have. It's the amount of memory that you have. It's the battery power that you have. It is the angle that you normally hold your phone and the speed at which you walk. I mean, the amount of things that these phones can gather because they operate in three-dimensional space and can return that information using location services, the amount of information they can point out, like they can determine if you're left or right-handed, roughly how tall you are within a couple of inches, your literacy level based on the way that you type, the speed at which you type, and the vocabulary that
Right.
you
Whether
choose.
English is your second
It's
language.
insane how precise these things can get. And then it gets right down to the digital footprint, which is going to be the updated version of the browser that you're using, whatever you're using for the number of updates for your specific mapping services. Like I said, the interacting plugins that you have and all this stuff. It is a truly unique, almost more like a genetic modifier to you, which
Right.
obviously you need to have a warrant to go and swab for. It's it's
Right, exactly.
it's just
And
very, very
what the
specific to the
court
person.
said, Kyle, I don't know if you've looked at the
I
opinion. The
haven't,
court said,
no,
oh, well,
but I
they only got 2 hours worth of data on the person, so it's not very much of an intrusion at all. And I was like, you don't understand how this works, is the problem, Fourth
yeah,
Circuit.
that's like saying I'm going to collect 2 hours worth of the skin falling off your body, and then I'm going to go analyze it. I'll get everything. I'll know whether you have genetic markers and
Right.
preconceived
What
conditions, and
disease you're prone to, right?
it's insane how much you get
Yeah,
off a cell phone with just a couple of minutes worth of hits.
I
right.
I,
I
I
but
know.
thought that reading the Fourth Circuit opinion, I was kind of struck by how irreverent it was in places. Like it like it didn't even seem to take some of these issues seriously the way it just
Oh, yeah.
dismissed
Yeah.
them. And the point you're making right now is the one that struck me the most, which was, well, we're just looking at a 2 hour time period. We really can't the government really can't learn a lot of things about your daily habits just from looking at what you were doing over a 2 hour period.
Right.
well,
It's more like looking at a CT scan of somebody and saying, "Look, it's just a brief
Right.
moment in time. We're just looking through all their body tissues and finding out what densities they are." It's so
Right.
much more invasive. It'd be nice if the justices and the judges that had to rule on this kind of stuff got about a 1 hour briefing on a classified setting, sitting in one of the NSA skiffs like I've been in, because once you've
Right.
been in there, you go like, holy
Oh
shit,
my
there's
Yeah.
God.
no way
Right.
that everything, like anything that, like, first of all, you're going to go to a jitterbug if you have any option to. And
Or what would be interesting is if there was a one-on-one sit down with a judge in a skiff like that with, let me tell you what your phone tells us about you.
that's
Yeah,
exactly right. They don't
use their
personalize it.
phones for examples. I've often said that in basic criminal cases. Like they're like, "Oh, well, being detained for 4 days and then being brought in front of a judge, that's no problem." And I thought, you know what? If you were locked up for 4 hours, you would fucking be freaking out. And yet you're saying it's fine for people to be locked up for days at a time. So it's the same kind of thing. If it was done to them, they would lose their minds.
But
well,
even like we talked about drop phones, but I've actually used data from Google warrants to identify people on drop phones because they you repeat the same patterns, and so they
Yeah,
keep so much detailed patterns on what's going on with the phone that you can tie them together and actually ID somebody from that.
it's like an MO. Yeah, that makes sense.
So, I mean,
So,
people, what you have to realize is that you have a pattern, your phone has a pattern, your phone has habits that are the same as your habits. They leave the house at a certain time, they get picked up and charged at the same time, they get left in the same places physically, right? They interact with the same groups of phones, which is why I kind of had some things when they were talking about the Trump assassination, for example, and they're like, or the attempt on him, and they're like, oh, there was a phone, and my friends over at Heritage, did some work and said, oh, there was a phone that was around their house all the time. Like, you don't know all the phones that are around your house all the time because there's a gardener that your neighbor has, and there's the guy that checks the water meter, and there's the UPS driver and the Amazon delivery and your postal worker and any number and a dog walker that lives in your neighborhood that you've never seen but walks in front. So all these phones have patterns and they all exist, and it is far more
And
aggressive,
they're all on your property or going by
and
it.
they're pinging
So,
against your Wi-Fi networks and so on, because even if you're not
right.
connecting to the Wi-Fi, what's going on is your phone is actively reaching out, trying to establish a connection and realizing it's unable to do so, but it still leaves an impression on the places that it goes. So all of these things are happening all the time. Again, you're correct. There's a lack of empathy from these judges making these decisions who have never been on the other end of it and they don't see it. And if you are an empathic kind of person who goes like, "Hey, I'm a citizen first. I happen to have this job, but like at any moment, this could be turned against me. How do I know? Because I've seen people have it turned against them. And I want civil liberties first. And if that makes my job more difficult as a Fed, so be it, or as any law
Well,
enforcement
that's going to
professional."
have to be the way it is.
Yeah.
Exactly. But
Well,
I always tell people who are right of center, because right of center is very law and order. Of course, we are. Even as a defense lawyer, I was pretty law and order in a way, right? But what I always tell people is, look, you have to think about this. How would you want these rules to be set up if your son or your daughter was wrongfully accused of a crime? Like, that's what the standard should look like, but that's not what we do.
or
Because
put on
we're going
some
to catch
list.
the bad guys. You're catching the bad guys anyway,
I
right?
mean, I think the worst part of it is that they're scooping up this data and putting you on lists and doing, keeping you from doing stuff
Yes.
that has nothing to
And
do
you
with
don't even
you,
know it, how you got on this damn list. Right.
and you haven't committed any crime. You have,
Right.
and you have
Right.
no, you
Exactly.
don't get to challenge any of it.
Right. Which is a whole other set of problems.
Let me throw one more, like just
So,
like monkey wrench out there for people who are listening, just for their entertainment. One of the things we used to do with source phones that was definitely not approved, and I was told I was not allowed to do, but it made more sense than not, is before I was done with it, because you have to cycle them out, right? As Aaron was saying, if you want them to be
mm,
remaining anonymous, they have to disappear with the pattern. The problem is that they did a pattern, and then what do you do? You can't get rid of the pattern. The pattern already exists, and Google has it, or whoever else has it. But what you can do is you can muddy up the water. So if you put 20 bucks worth of minutes on it and hand it to a homeless person, it's probably going to be traded for tricks and on the other side of the country, like by the end of the week, which is really weird because it'll ride the rails and do all kinds of weird shit. So if you're trying to confuse a nation state, that's much more interesting to me than trying to destroy it, where basically a phone goes and does a couple of loops, talks to the same people, and then just gets destroyed. That's really suspicious if you're able to have access to the data. But if it just suddenly like starts getting traded for heroin and ends up in like British Columbia or something, like that's a totally
then
different
it
animal.
doesn't make sense
Right.
anymore
So
to the
you can
pattern.
obscure
Yeah.
your patterns by doing things like this. And if anybody's really like panicked out by this stuff, by the way, read Extreme Privacy, which is written by Michael Bazzell.
Yes. Yes. I recommend that as
Yeah.
well. Right. Yeah. That person's having an affair, right? Or they're doing a illicit deal, right? The short term, the short term use. So, but okay. So we've got these two cases now. I have thought that this was unconstitutional the whole time. Okay, because as a defense lawyer, I've seen the horrible from the beginning, early days, and the question is now what is going to happen. So these are recent decisions. They only bind, a small part of the country so far, and the Fourth Circuit, which covers Maryland, Virginia, and North Carolina, thinks that this is no problem. So, as I said, I don't know if it's bubbling up in other places, and I wonder if, given the nature of the issue, if the Supremes might be interested in taking one or both of these cases as sort of companion cases before the other circuits weigh in. Often, I think they wait too long. They wait for too many circuits to weigh in when there's already a clear division.
Uh,
King and Chip, what do you think about that? Will they take these now, or will they wait for more circuits?
it, if they're aware of what's going on, I think they wait because this may become moot. Uh, Google cannot go on, and the
Mm-hmm.
government cannot go on waiting 6 months to get a result and from a search of 600 million users every time they get a geofence warrant. That's not very efficient, and I. Uh,
I mean, in
but
the right kind of case, they will. They're looking for a murderer, they will.
but
But
I expect Google to change its way of doing business.
yes. Now, wasn't it Apple recently was saying that they're also going to change their policy or their procedure so that the location stuff is just on your phone?
Yes.
They're not going to keep it anymore
Uh,
in a main
Well,
database?
Apple does not.
yeah.
Apple, that's
App,
one of the. I think
Oh, is
that
it Google
yeah.
that was going to
It's
switch
only
to
Google's
that?
Google right now. Yeah.
yeah,
Yeah.
and Google is making changes to the way they store data so that something else I should mention here. I think a lot of people don't know when a corporation responds to a search warrant, it doesn't get paid.
Right. It
It,
costs them
the
money, which is
cost,
what affects them.
right? The cost is all on the corporation to comply with a search warrant, and so these they make reference in the Fifth Circuit case to the use of these warrants has become damn near ubiquitous. They are using them for car break-in cases. You know,
Wow.
they are using them for simple street crimes because it's how they identify suspects now. They
Right.
have the crime, they have the location, they have the time period, so they want a geofence warrant. And,
It's
and
easy.
and that's
Yeah.
why last year, or I think it was 2022, in the Fifth Circuit case referenced in 2022, geofence warrants being 25% of all warrants received by Google. One
Wow.
out of four is a geofence warrant, and King's reference was accurate that it's now a 6 month wait in some instances before they get the returns. Um, and this is costing Google hundreds of millions of dollars. Now, Google's got it. That's not an issue, but I'm sure they would prefer to spend their hundreds of
Yeah,
millions
they'd
of
rather
dollars
spend it on
elsewhere.
other things.
So,
Kyle is right though. It's not just Google and an iPhone. Of course, Apple. It's basically any app that tracks data.
well, but they have to store it. They have to
Right.
store it. And Google is the only one that I know, based on these opinions, Google's the only company that stores this data in such large quantities that it
That
is
is useful to
effective.
law enforcement.
Right,
So it
right.
it's it's not just that they store it, it's that everybody has a Google product on their phone, which is
Right.
why that Monopoly case came out saying that there's basically a 90% penetration on desktops and 95% on handhelds, that Google is on your phone or is on your device at home, so they have access to everything. There are plenty of other companies that are hoarding your data, but they have much lower penetration of the market, so it's not nearly as useful. If you want to hit the
Useful.
biggest thing, you throw the biggest net, and the biggest net is Google.
Well, also keep in mind
What I'm saying is,
we have
if
to
Google
articulate
changes, yeah, go ahead,
probable
Aaron.
cause in the warrants too, and
Yeah.
it's easy to do with Google because everyone's got one, so it's easy for us to say, hey, pretty much everyone's got a Google account, so we have probable cause to believe that they had some location data. Whereas you couldn't do that with I don't know, your Nike running app or something like that, right? You
Right.
couldn't make that same statement.
Yeah, but law enforcement being what it is, if Google changes its procedure and it doesn't have the data, law enforcement will just shift to something that, well, a lot of people use and see what they get, right? So it'll filter down through the industry. But it would be better if the courts were to say the government shouldn't be doing this in the first place because this is not a warrant that complies with the Fourth Amendment.
Well,
So Google should be able to store that data, assuming there is some commercial or you customer reason for doing so. Maybe there isn't. Maybe they've just been doing that by default.
oh, no, 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 no. They store the data because it's valuable. They
Right.
store the data because it's what they use to target advertising. Uh,
Right. So this is capitalism in action.
right.
So if the government is prohibited from using it for law enforcement purposes, then Google can go back to doing that for capitalist, concerns. But the courts are going to have to step up and do what the Fifth Circuit did and say, this is off limits, guys. I know it's helpful, but you know what? General warrants are super helpful for the government too, right? Searching people's homes without warrants and without judicial oversight is very helpful for cops. But, we've decided that that's not the way we want to do things.
Yeah. I mean, I disagree with King. I actually think the court will take this up this term. I think the approaches of the Fourth and Fifth Circuits go in two completely different directions, and I think this is one of those subjects where the Supreme Court cannot sit and say we're going to let different areas of the country operate under different rules when it comes to the validity of search warrants. Um,
Yeah, my instinct is the same too. And I was really struck by both courts saying this is just a straightforward application of Carpenter, and yet they reached different decisions. That should bother the court, the Supreme Court.
Yeah, I think. Well, I think it's the fundamental question is it a search or is it not a search?
Right.
I mean, they come to I mean, that is the fundamental question on the expectation of privacy, and they come to opposite conclusions on nearly identical facts, and both, as you say, purporting to be interpreting Carpenter, and the Supreme Court, but from these two cases, could at least resolve that issue.
Yeah, right. And Carpenter's not that old, so it's a situation where they can flesh out what they had to say. And you can see in both Jones and Carpenter, they're trying to move slowly and incrementally. The problem again is that they're already so far behind the technology curve,
Right.
right? They're making decisions that reflect what the technology issues were for the guy on the street 10 years ago already.
To me, the biggest the explanation for the Fourth Circuit and the Fifth Circuit going in opposite directions is largely generational. You've got a Fifth Circuit judge who's 86 years old. I'm 10 years her, she's 10 years my senior. But I can personally attest to the fact that when I'm flipping through screens and trying to figure out where the location stuff is and getting confused along the line, at least
Right,
somebody of my vintage, uh, it is it is not a voluntary thing. It just
right.
happens, and that's what Judge King hit on. Whereas the Fourth Circuit took a more of a modern approach. Everybody knows it's not your stuff and it's going out to the public.
Right. Except it's not going out to the public. This is on this third party issue again, right? It's going out to services that you pay money to
Oh,
perform services for you. They're
oh,
your
oh no! But
agents.
you clicked according to the Fourth Circuit.
Yeah.
You clicked yes. I want my location to be kept by Google and stored. Uh,
Right,
oh,
but that's what I'm saying.
yeah.
Even if you did that, okay, but you're paying them for a service. That's part of the contractual arrangement between the two of you. I have never been able to understand how that erodes the expectation of privacy. You haven't clicked something that says everyone in the world gets to know where I am going, just the people who are running the programs that I'm paying to use.
And everybody they said that they sell ads to.
Well, yeah, in theory, that when you agree to offer that, these things are not even supposed to be touched by people. I mean, that's the understanding is that it's going to be
Right,
anonymized. It's going to be
right,
completely based on preferences and algorithmic, software running on. That's not going to
right.
have some
The
human. It's
system.
not going to have a human being like an FBI agent or an IRS agent or take your pick federal agent going in looking through your data to figure out where the hell you went because they're now trying to solve a crime and you just happen to be in the right place to be evaluated for whether or not you actually meet the criteria that they have for who that criminal was. So it's
And I don't understand why the courts struggle with that because they would surely say, if we were doing old flatfoot law enforcement, right? Cops can canvass a neighborhood, but people don't have to answer the door, or they can answer the door and then not answer
I was
questions.
thinking it's kind of more like the sort of the technology jump that happened when thermal imaging became possible. Was it Kylos was the
Ah,
decision, right? So the
yeah,
ability to peer through walls where you do have an expectation of privacy, but obviously my tools can violate that if I was able to use it. And is that a search or not? And it's like it's pretty obviously a search because the
right.
naked eye couldn't see it. So they had some tests that they could see because I think because it related to a physical sense. And it doesn't relate to this nebulous concept of cloud-based data and the
Yeah,
algorithmic searching and the fact that we're talking about spreadsheets which can be translated very quickly into points on a map which looks like where people are, but if you don't have that ability to grasp it or if it's just not something that comes naturally to you, spatial thinking is not something that happens for every person. And
yes.
GIS is pretty obscure. If you go deal with GIS people, they're weird. They're kind of nerdy and strange. And people that can compute this stuff at the level that we're talking about for Google to be able to process this information, they're not everywhere. That's why it's a uniquely and probably reasonably well-paying position. It's why the cast people are very unique among FBI agents and specific in law enforcement. It's not like every single agent has the ability to take this stuff and turn it into something and go, aha, you've sent me this data set that looks like a bunch of garbage, and now I'm able to translate it into DOS on a map somewhere. That's just not how it works. So it's a unique
Right.
skill set. And if they had more appreciation for that and was able to see it, maybe if they sat with a cast guy like we were talking about, like literally a briefing in a skiff would change their minds. I guarantee it.
Right. I agree with you. So, all right, King, was there anything else you wanted to say about these two opinions, sort of compare and contrast?
No, I think we've covered it.
Yeah. And then, so I'm going to get back to you about your story here in a second. But let me ask Ship, what about you? Is there anything else we want to tell the folks about about these cases?
No, I think it's a subject to watch closely and to pay attention over the next 12 to 14 months.
Right. I am hopeful that the Supreme Court will go the right way, the way the Fifth Circuit did. And that we're going to get more and better opinions from the federal courts on this. I'm hoping, because I do think that as the technology gets pushed out to everyone, that the judges, in fact, do start to develop some empathy. Clearly, Judge King in the Fifth Circuit has empathy. Because it's something that they can then understand from their own experience, which in the past, I think they were just completely out of their comfort zone with these tech cases. Kyle, have you got anything else you want to tell us before we let King sign us off with his story?
The comment is essentially that the right answer, as you just indicated, should err on the side of individual liberty and make more of a burden for the government. That's a burden that they're prepared to lift. They have unlimited resources if they so choose. But the question is if you guys were bookmakers, if you were making odds on this, how do you think this
Mm.
goes with the current constitution of the court?
I think as long as Neil Gorsuch is on the court, I have confidence that this kind of case is going to come out the right way. He's the most libertarian of the justices. And so when you get to cases that really have to do with liberty interests, whether the right likes the issue or the left likes the issue, he sides with the liberty oriented group. Do you follow what I'm saying? So I have confidence as long as he's on the court. But that's just my own personal view. Chip, King, you guys have any thoughts on Kyle's question?
I think
How confident are we that court will go the right way?
I think
King?
it's a flip of the coin because you've got you've got a system, a technology that most judges don't understand, and on high level, uh, you have a serious. Is this really an expectation of privacy uh, state here? Given that practically everybody who has a cell phone understands their data is being sold and used by advertisers.
It sort of puts the cart before the horse, doesn't it, though?
It, it
I really hate that argument. It's
I
like,
don't like
okay,
it.
but
I'm
that
just
shouldn't be. Yeah.
it, but it. I'm with you. I think
Yeah.
the Fifth Circuit got it right. I just
Yeah.
worry. I think it's a literally a flip of the coin as to which direction the Supremes would go in this high tech world of ours.
Yeah.
Which
It's like the snake swallowing its tail. Okay, everyone thinks that's the rule because you guys have said that there's this third party theory. If there's no third party theory, then you're just wrong about the whole thing, you courts. And the people are correct that they think there is an expectation of privacy. Because when I tell people on Twitter, oh, well, the government doesn't need these warrants for certain kinds of things or whatever, people don't know that that's the situation. They think it's obvious, like really obvious, that you have privacy in the information on your phone. That's the everyman's approach to it. For the courts to go the other way, I think is seriously problematic as a culture.
Yeah, I don't think people realize that oftentimes we didn't need the phone. Like we would reach out to
Mm,
the provider and to the cloud. We get
right,
everything that we
exactly.
need from there, and like we don't need your phone.
Your physical phone, they don't need. I agree. People don't. They think they just don't understand how it works at all. And then the courts have set up these rules that are I think contrary to normal views about it.
Well,
Chip, what do you think?
the one that should scare everybody here is the one that is sort of antiquated. The statutory provision that says no warrant is required for emails more than 6 months old.
Right.
So I'm going to guess that
The
nine.
Congress has never been able to get up off its ass and amend that, and the
Yeah,
reason that they don't is because the DOJ goes up there every time it gets proposed and whines and cries and tells them that they need those old emails for law enforcement
yeah, and
purposes.
this go that provision saying that if an email is more than 6 months old, the government can get it with a grand jury subpoena. It doesn't need to get a warrant, meaning they don't need probable cause. That basically goes to AOL dial-up, or what was before AOL? What was the CompuServe?
Yeah.
But
Yeah, CompuServe.
and it was
Right.
because that they didn't keep emails more than 6 months. That CompuServe
Right.
couldn't store emails more than 6 months. So that was never a problem because there weren't emails more than 6 months old for the government ever to get. Well, that's
At the
that's from
time
like
that that
that's from like
rule was put in
1995,
place.
right?
Right, it is. Yes, it's a statute from the Congress, so people understand. So it basically says any email that you have in your inbox, in your folders, right, in your system, if it's more than 6 months old, it's been basically deemed abandoned, and therefore the government doesn't need a warrant to get it. They could just issue a grand jury subpoena for it. So basically, anything on your phone that's an email that's more than 6 months old, the government can get. They don't have to go to a judge for. And when you tell people like that, they're horrified because, as I've been saying, people think that that stuff is private when it's not, which should be informing the judges about what the actual expectation of privacy is by actual people, the citizenry, except somehow that doesn't get translated. It's appalling.
And
But
then
the
And for
Congress could change that at any time, but they
right,
don't have the
they
cojones to do so.
they could just
and for
amend
most
that statute.
cases, most cases that we're working, they're historical. By the time we would get a warrant, you would be at 6 months anyways.
Yeah,
And
right. You're working a 3-year-old case to begin with, so it's all up for grabs.
and you're talking about, I mean, people. I would get a million emails in our warrants. We would always get warrants, so I never actually subpoenaed that I recall. But we would have always hundreds of thousands, but often up to a million emails in a criminal's account that was only using them for crime. In a regular person's email account, it would be substantial.
Right. The clients have all said to me, "Well, how can they get that? That's my private email." And I'd be like, Except it's not, unfortunately for you, under the law."
Yeah, and the other one is people don't. I think they don't have an appreciation for the fact that they require they have to have a warrant to get your iCloud account. But once they have your iCloud account,
Hmm.
people really have no conception of how much they communicate by text message.
Right.
Every text message that you have ever sent is stored in if you get an iCloud account, you get 50 gigabytes for $1.99 a month. Well, 50 gigabytes is millions of text messages.
Right.
Well,
This
also
is
photographs. Photographs
this
is
is
a
also
huge
the
one.
This is the argument on behalf of end-to-end encrypted apps, and it's also, if you notice, the reason
Yeah.
why places like the FBI and both most recent directors have fought it. Comey did it. Ray does it as well. The whole concept of this going dark initiative is something I continually try to remind people about. The reason that they don't want to have to deal with more difficult tools to crack through end-to-end encryption is because it's a lot easier if you don't have to deal with that. But the fact of the
Right.
matter is just because a tool and a technology can be used for nefarious intent doesn't mean that you throw it out and don't let anyone use it for anything that has a perfectly reasonable and liberty-based excuse, which is that you don't want the government in your stuff, and so you
Well,
you should
see,
be able to keep those
Kyle, I
things.
always, I always think, how is this different than the mail? Right? It's no different than the U.S. mail. You can use the mail for good purposes and bad purposes, and we have
Are
never
we
said that
talking
that
about
means the
Uncle Ted
government
right now?
can. Yes,
Yeah, Uncle
exactly.
Ted used it for bad.
Right. But you know what I'm saying? Like, no one has ever said, well, the government can read your mail because that's the OG encrypted, communication. You mailed your letter. The government wasn't allowed to open it.
Although
That
I
was
will
the way it
say that
works.
we can very easily find out what's coming in and out of
Well,
your
yeah,
mail.
that's a joke as far as how easy that is. But
Yes,
actually getting into it, it requires either, it requires more process, and in theory, there's
exactly.
a higher level of scrutiny, and there's supposed to be probable
Yeah.
cause.
Right.
And even the
Exactly.
national security vision of it, where they're doing these, there are reasons, there are ways that you can make this happen. But yeah, bricks and sticks is the way you overcome a lot of this stuff, which is the old school trade craft of leaving, what they call bricks and sticks. So it's like literally writing things in chalk and leaving certain markers in certain places because it is. hiding in plain sight. But the idea that you would have encryption and the government shouldn't have access to it is a no-brainer. And what's amazing to me, and this is the reason why I actually left the FBI Agents Association. I broke up with them, and they called me, the president, who was in Tennessee, I think. We had an hour long conversation where he's yelling at me about how, like, we need this tool and we need to be able to hack all and encrypt it. And I was like, you're out of your damn mind. Like, there's no way.
Right.
Just because somebody can use it to hide child pornography also means that I can have a conversation with my wife that you're not allowed to have. You can't have it.
Right.
You don't get to see it. And screw you if it makes your job harder, bro. Like, I don't care. Because if you look at yourself as a citizen first, and this is,
Yes.
again, the education, the empathy that the judges need to have, putting people in the position of, at some point in time, this could be turned on me. How would I want it to be? Would I want the most amount of protections afforded? Should I have certain, privacies that are considered? Or is it my own fault because I'm too dumb and I clicked on the terms of service and I've given up everything, and like the default position is screw you? And that's not a good way for us to operate. And
For
it's
run the railroad.
yeah,
Exactly.
it doesn't function in reality if people don't. And the other thing is this, like, we're having a pretty cerebral conversation about this, and we're not talking about it
Yeah.
in terms that are outside of people's grasp, but there are plenty of people in the world who live on your street that don't understand. If they listen to this space, they would walk away and be very confused and not know what they were missing. And so there's a lot of people that can't even grasp the terms of service on their best
Right.
day. So are we just
Right.
leaving them in the lurch and saying, because you
They're
have a,
just left out in the
yeah, if you
cold
have an average
because,
IQ,
yeah.
you're screwed and you're just going to default to being like looked at by the government?
Right.
That's not a good position either. So.
No.
Well,
But I'm
you
struck by
speaking of
your comment about the attitude, the approach toward, well, if you let people have encrypted, end-to-end communication, then they'll just use it for nefarious purposes. And I always think to myself, okay, but how is that different from I send you you can send a letter in the old days in 1952, right? It's like not any different. No one in their right mind would say this is an acceptable argument. We can't have mail, sealed mail that can't be opened under penalty of law, right? Because people might use the mail for nefarious purposes. No, that's not how it works. We set up statutes that say you can't use the mail for certain illegal purposes, and then you have to have proof that they're using it for an illegal purpose before the government can access it. It's not at all different. It seems different because it's technology, but it is not
Then if
different.
people knew how much cocaine was sent through the mail and through the UPS and FedEx, their heads would explode.
Seriously. Right, exactly. Come on. Right.
well, I
So,
mean, this is a discussion for another space, but you saw that the Telegram founder got picked up in France.
yes. Yep. Yeah, right. Because somehow the government has this attitude that you shouldn't be able to keep things private from them. And I'm with you, Kyle. I'm like, who in the hell made you the decider that that's how the world should run? No, we decided the opposite of that. Yeah. Steve, did you want to weigh in here?
I just wanted to pick up on the comment that that this may make the government's job harder. In the Fifth Circuit decision, Judge Ho, who was a very conservative judge, concurs and makes the point that the entire purpose of these amendments to the Constitution, the Fourth Amendment and the Fifth Amendment, among others, is to make the government's job harder. If all we cared about was making the government's job easier, then we'd have adopted the general warrant system that the British had, because that makes law enforcement's job easier. And we opted the other way when we put together the Constitution and framed it. And so it's a matter of following that spirit down to the present. And I think that that's exactly the right attitude, which is, yes, it does make law enforcement's job harder, but that's the whole reason that we have these protections.
Right. It's supposed to be protecting all of
on
us.
on top of that, and we already know that this is the case because good law enforcement practices, your standard sort of operating procedure should always be not only get whatever necessary paper you need to get, but also get consent if possible. So nobody goes out there and says, I'm going to serve this warrant. And, there are days when you have to knock the door, obviously, but if you get a chance to be able to get a consent search too, it's going to hold up even better. Like, we want all of those things. So you're always going to try to get more layers of showing that you were on the up and up instead of trying to like shortcut it. The problem is we've got a generation of people that are younger and think less maybe of civil liberties, and maybe they don't think the same thing about privacy, because we've got the first generation of law enforcement officers out there on the streets right now and working in federal and state and local that that grew up in a digital age and had a lower expectation of privacy than those of us who knew that, like, there were people in the 80s when I was a kid who just decided to change their name and moved, and they became somebody else, and they were able to do
Right.
that. That's
Boy,
not
my God, you can't do that
it's not
now.
possible
Jeez
anymore,
Louise.
right? It's just
Right.
it's totally impossible and implausible to imagine that somebody would just pick up and change their name, change the color of their hair, and just be a new person because they were being abused by their husband or whatever. That just doesn't exist today, and so they can't conceive of a world where you have this default right to privacy and anonymity, and they think that being tracked is normal, and so it changes the perspective of those that are actually even doing the work too, I think.
Yeah, I agree with you. Okay, so we're hitting almost 2 hours here. So we often, I don't know, Kyle, if you know this, but we often like to end with a story from King since he's the oldest of our group and has great, what lawyers call war stories. This, I think, is not a war story, but a love story, King.
The-
So you want to lay it on
oh,
us?
it is. Absolutely, it is. Even though the object of my affection is 10 years older than me. Uh,
Is your wife aware of this,
yeah,
King? I have to ask.
she is aware. And it's been going on for 45 years. That's about when Judge King, then Judge Randall, uh, was appointed by Jimmy Carter to the Fifth Circuit. She went on to become chief judge for a while. She was on the court forever and is now senior status and still hearing cases as this Fourth Amendment case, geofence case shows. And she's the same judge now that she was back then. And I know that personally because not long after she was appointed, I had a case before her. She was on the panel, and the case involved some obscure accounting issue. My case lived or died on how the accounting issue came out,
Oh, lawyers love that.
and but the tough part was I was trying to prove my side in the trial court, and my expert CPA, who was a member of the one of the big eight firms back then, had qualified his expert opinion per instructions of his corporate leaders with a disclaimer that began with, since we did not do an audit, we have no opinion. And that's as far as the trial judge got. We have no opinion. And he read that. He looked at me. And he says, Mr. King, your witness is not a fact witness. And he says he has no opinion. So he's not an expert witness. Please call your next witness.
So he's not a witness at
He's
all.
not. So and didn't say at the time that I didn't have a next witness. So I turned around and looked, and I was up at the podium. I turned around literally and looked, and the only potential witness I saw was sitting next to opposing counsel, and that was the other side's expert witness who had
Okay.
signed the audit opinion that was at
Aha.
issue. So I called that sucker and put him on and cross-examined him blind, pretty much. And of course, I lost. And
Right.
and I convinced my client we should appeal, and we drew a panel with Judge Randall, now Judge King, in one of her first cases she heard, and the argument went, you know, neither here nor there. But damned if the opinion comes out and Judge King wrote the opinion in my favor, reversing the district court. And since the other side didn't have any other evidence other than the guy I put on, she ordered judgment rendered in my client's favor.
Oh, wow.
And what she had done is she took the trouble to go to the transcript and read my cross examination.
Aha.
And because I thought I had proved it uh,
Through this other witness.
through
Good
the
for
other
you.
witness. Uh, well, I didn't, I was patted myself on the back. Client was happy.
Yeah.
But 3 years later, I was at a cocktail party with a whole bunch of lawyers and a judge here or there. And Judge King was there. I saw her way across the room. And she saw me, and she came all the way across the room over to me. And she says, "What's your name again? You're that lawyer with the accountant." I said, "Yes." And then she said, I've read your transcript. And she says, "You tell me about your education. Where'd you learn all that stuff?" I said, "Well, Judge, I never had an accounting course in my life. I kind of learned on the fly like trial lawyers do." And she went on and on about how had she saw something in my brief that caught her eye. She pulled out the transcript and read it A to Z, and figured out I was right. And I walked out of there with an ego big enough to fill an indoor football stadium. Now it's been deflated many, many times since, but ever since
But
then,
she has a
I've had a
soft spot
crush
in
on
your heart for that.
I've had a crush on Judge King, and she has not lost her touch at all. If you read her opinion,
Oh no, she's sharp. Obviously, you
she
can
had,
tell from yeah.
and she
So,
has retained that ability to dig down to
hmm
the essence of things, uh, and that's what her opinion showed. She got into the minds of what was going on at Google, and how does it appear to an average phone user, uh, and she picked up,
and then she applied the law to that,
and
which that's the way to
that
go.
is,
Yes,
I wish we had more judges like that.
me too. Yeah. All right. Well, good hearing your story as always, King. Thanks. And thanks to Kyle and Aaron. You guys were invaluable tonight, helping us work through this issue, and hopefully people are understanding. I always appreciate that. So I think we'll quit for tonight. I'll say good evening to everyone, and we'll talk to you guys next time. Good night.
Good night.